Preliminary investigation and due process. It is doctrinally settled that the right to preliminary investigation is not a constitutional right, but is merely a right conferred by a statute. The absence of a preliminary investigation does not impair the validity of the information or otherwise render the same defective. The denial of the motion for reinvestigation cannot likewise invalidate the information or oust the court for its jurisdiction over the case. The right may be waived expressly or by failure to invoke it. It may be forfeited by inaction and cannot be invoked for the first time on appeal. But where there is a statutory grant of the right to preliminary investigation, denial of the same is an infringement of the due process clause. In such cases, the right to preliminary investigation is substantive and not merely formal or technical. To deny it to the petitioner would deprive him of the full measure of his right to due process, from the case of Yusop versus Sandigan Bayan. A preliminary investigation is held before an accused is placed on trial to secure the innocent against hasty, malicious, and oppressive prosecution and protect him from the trouble, expenses, and anxiety of a public trial. It is also intended to protect the state from having to conduct useless and expensive trials. Thus, while the right is statutory rather than constitutional, it is a component of due process in administering criminal justice. It is now provided in Section 1, Rule 112, Rules on Criminal Procedure, that a preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day, without regard to the fine. However, when a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the complaint or information may be filed by a prosecutor without need of such investigation, provided an inquest has been conducted in accordance with existing rules. In the absence or unavailability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the court on the basis of the affidavit of the offended party or arresting officer. Before the complaint or information is filed, the person arrested may ask for a preliminary investigation in accordance with this rule, but he must sign a waiver of the provisions of Article 125 of the Revised Penal Code as amended in the presence of his counsel. Notwithstanding the waiver, he may apply for bail, and the investigation must be terminated within 15 days from its inception. After the filing of the complaint or information in court without a preliminary investigation, the accused may, within 5 days from the time he learns of its filing, ask for a preliminary investigation from the same right to adduce evidence in his defense as provided in this rule. Be that as it may, the lack of preliminary investigation is not a ground for a motion to quash. The case must be suspended with respect to the petitioner even if the case is already undergoing trial. The right is not waived by the filing of motion to be admitted to bail, but the right is waived when the accused fails to invoke it before or at the time of entering a plea at arraignment. The preliminary investigation conducted by the DOJ is merely inquisitorial. It is not a trial on the merits, and its sole purpose is to determine whether a crime has been committed and whether the respondent therein is probably guilty of the crime. It is not the occasion for the full and exhaustive display of the parties' evidence, and upon satisfaction of the investigating prosecutor that probable cause exists based on the evidence presented, he may terminate the preliminary investigation and resolve the case. From Judean Santos versus People. A preliminary investigation is essentially an inquiry to determine whether a crime has been committed, 1, and whether there is probable cause that the accused is guilty thereof, 2. The public prosecutor determines during the preliminary investigation whether probable cause exists. Thus, the decision whether or not to dismiss the criminal complaint depends on the sound discretion of the prosecutor. Courts will not interfere with the conduct of preliminary investigation or the reinvestigation and the determination of what constitutes sufficient probable cause for the filing of the corresponding information against the offender. In Sanrio Company v. Lim, the Supreme Court reiterated the policy of non-interference with executive discretion in the determination of probable cause. It held that the public prosecutor is afforded a wide latitude of discretion in the conduct of preliminary investigation. The possible exception to this rule of non-interference as held in Aguirre v. Secretary of Justice is where there is an unmistakable showing of grave abuse of discretion amounting to excess of jurisdiction on part of the public prosecutor. Such grave abuse of discretion will then justify judicial intrusion into the precincts of the executive. Consistent with the rights of all persons to due process of law and to the speedy trial, the Constitution commands the Office of the Ombudsman to act promptly on complaints filed against public officials. Thus, the failure of the said office to resolve a complaint that has been pending for 6 years clearly violates this mandate and the public officials' rights. In such event, the aggrieved party is entitled to the dismissal of the complaint. This reiterates Tatad v. Sandigan Bayan, where the court said that the unreasonable delay in the termination of the preliminary investigation by the Tanad Bayan violated due process clause. But where the delay is due to the complexity of the issues resolved or involved, or is caused by the petitioner's own actions, not by the inaction of the prosecution, there is no violation. Administrative due process. In Ang Tibay v. CIR, the court enumerated the requisites of administrative due process as follows. A. The right to a hearing, which includes the right to present one's case and submit evidence in support thereof. B. The tribunal must consider the evidence presented. C. The decision must have something to support itself. And D. The evidence must be substantial. E. The decision must be rendered on evidence presented at the hearing, or at least contained in the record, and disclosed to the parties. F. Tribunal or any of its judges must act on its or his own independent consideration of the facts of the law or the controversy, and not simply accept the views of a subordinate in arriving at a decision. And the board or body should, in all controversial questions, render its decision in such a manner that the parties to the proceeding will know the various issues involved and the reasons for the decision. Due process in quasi-judicial proceedings before the COMELEC requires notice and hearing. The proclamation of a winning candidate cannot be annulled if he has not been notified of any motion to set aside his proclamation. In Namil v. COMELEC, the COMELEC issued the questioned order annulling the proclamation on the basis of the private respondent's allegations and the recommendation of the law department without giving due notice to the candidate proclaimed. Thus, the COMELEC order was declared void.